We really think we have a great legal writing program here, and one of the best parts about it is the oral advocacy portion of it in the spring. We organize all of the first-year students, and so that and it takes about a week and a half to get through them all, and we have a number of arguments going at the same time. So the students will come in. They have been prepped for the oral argument. We talk about oral advocacy in class. We show a video of oral advocates. Interestingly enough, the video involves now Chief Justice Roberts when he was a practicing attorney. And so we critique that in class. And then we actually have a practice argument in class as well, where I get 2 volunteers to actually perform the argument or do the argument with me as the judge in class. So by the time the students go in for the real argument, they're very well prepared. They're always really nervous. I tell them that some of them have been looking forward to this kind of thing while they came to law school. Others are like, I never want to get up there. I will just be scared to death. And I would say easily 99% of them afterwards said it's the best experience in their first year. So what happens is that there's 2 alums and a Dillard Fellow. And a Dillard Fellow is an upper-class legal writing teaching assistant, are the ones that typically act as judges. And sometimes we'll also have a professor who is volunteering to judge. The judges have all received the students' appellate briefs, so they come very well prepared. And so we treat it very formally. We have the whole, the judges are all in robes, the students are in court attire and arguing before a podium. So we follow pretty much how it is, at least in the federal courts. And the students will start off, the appellant starts off, and I think what surprises students a lot is it's really not like a debate. Some of them have debated in college or high school, but it's really a give and take between the advocate and the judges. And I think what's exciting particularly for the students is they'll see that they can take part in this give and take. They know the problem so well that when the judge interrupts them with questions, they're able to formulate a really responsive answer. And it goes back and forth like that. And so they really understand how it comes together when you're advocating for your client, you're representing your client, the legal theories we've talked about in class, and it all comes together in a different format than the brief, kind of like a formal conversation with the judges. And that takes about 15 minutes per side. And like I said, it's not just a speech at all, it's really a conversation with the judges. And then afterwards, the judges will critique the students. There are no winners and losers in the first-year oral advocacy program. That's kind of not the point of this. But the judges will give detailed feedback to the advocates, and sometimes the judges will also actually return their briefs with comments on it too. I think a very rewarding part of the program is that we have a great involvement with our alums. In the fall, right before Christmas, we send out a big letter inviting alums to come back and judge the oral arguments. And we get a great response because they love to do this. They love to come back to the law school. They love to interact with the students. And it really gives the students a real world flavor of what practicing law is like.